If you have the 2-year green card based on marriage and you and your spouse jointly filed the removal of conditions application and it's pending, but circumstances have changed, you need to know the following. When I say change circumstances, what I mean by that is if your removal of conditions application is still pending and you and your spouse have gotten divorced, or there's been domestic violence and you no longer live with your spouse, or if your U.S. citizen spouse has passed away, in those situations, it's super important that USCIS is notified of those changes. If any of those situations have happened, then essentially you can notify USCIS that you're amending your petition to a self-petition. Let's say that the person never notifies USCIS of those changed circumstances, and USCIS ends up approving the removal of conditions application as a joint filing when it never should have been. It's going to cause problems in the future. An example of this, of where this issue could come up, is when the person goes to apply for naturalization. So whenever somebody applies for naturalization, USCIS will always look back into the person's case to make sure that they were eligible to get a green card in the first place. Now, if USCIS does approve the removal of conditions application as a joint filing and none of those changed circumstances that I talked about have happened, then that's fine. That's a different story. But like I said, just make sure if it's still pending and it shouldn't be approved as a joint filing, you want to make sure that USCIS is aware of that. If you have any questions about your immigration situation and you'd like to talk to me about them, you can schedule a consultation through the link in my bio or by calling my office, and that information is also in my bio.